charge not found on the law.
Yes.
By this time, the defendant has still not opened his defense. Neither was there any seriousness on his part to put it in effect. Because in discharging his duty to do justice, calmly and patiently advised the defendant to be cautious of the path he tended to take, as it was tantamount to resting his case on the part of the prosecution, which means that he admits the fact, evidence against him, but believes that it is insufficient to secure conviction against him. This court has been extremely patient and lenient with the defendant. He is only entitled to be given opportunity to defend himself as part of his right to fair hearing. Failure to use that opportunity granted by this court will be entirely his fault. He cannot complain thereafter of fair hearing. The right of a defendant to defend himself herself is a fundamental right, provided under Section 36 of the Constitution of the Federal Republic of Nigeria as amended. Such rights cannot be taken from a defendant except where a defendant the court informing him that it was minded to extend the date if he opened the defense on the 7th of November 2027. The court on the 27th of October 2027 made an order that the defendant come on the next day to put his defense or file his final written address, or any written address filed by him will be deemed as his final written address in this suit. Pursuant to this order of the court, on the 27th of October 2025, the defendant filed a motion on notice/comprehensive written address on notice on address on non-existence of a cognizable child and the unconstitutionality of continued of trial filed 30th of October 2025, and same will be deemed to be his final written address. That address is deemed as ordered by this court to be his final written address. The address as a comprehensive written address cannot be overemphasized. The word comprehensive, as used in that written address by the defendant, means, according to the online version of the Oxford Dictionary, is, and I quote, including, dealing with all, nearly all elements or aspects of something, unquote. The defendant in the motion on notice and comprehensive written address prayed for relief, including for the court to discharge him, which is a typical prayer in final written address in criminal matter. No doubt, the defendant clearly knew what he was doing by opting for final written address in form of motion/comprehensive written address in compliance with the order of this court made on the 27th day of October 2025. This will therefore be treated as the final written address of the defendant, and same have been treated and considered in the entirety. The defendant had also filed a notice of preliminary objection on the 16th day of October 2025. These two should be considered in the interest of justice, as the court having ordered that all preliminary objections will be determined in the judgments. Also, the preliminary objection filed on the 16th October 2025 is also considered thoroughly in these judgments. Another aspect of denial of fair hearing raised by the defendant is that he was misled into taking his plea in the charge. When the charge was read to was to be read to him, the court asked if he understood English. He responded that he did. When count 1 was read to him, he at first stated that he did not understand. The court ordered the registrar of the court to read the counts to him. He understood and took his plea. For the avoidance of doubt, I will reproduce part of the proceedings of 21st day of March 2025 when the plea of the defendant was taken. Registrar Nnamdi Kanu, do you understand and speak English language? Defendant, I do. Yes. Registrar, listening to the charge against you. Count 1. Register, after reading, do you understand count 1? I read to you. Defendant, I don't. Court, take it again. Count 1. Register, after reading, do you understand count 1? I read to you. Defendant, I do. Yes. Registrar, are you guilty or not guilty? Defendant, not guilty. Count 2. Defendant, do you understand count 2? I read to you. Defendant, I do. Registrar asked, are you guilty or not? Defendant reacted, I'm not guilty. Count 3. Registrar read to him and asked him, Defendant, do you understand count 3? I read to you. Defendant, I do. Registrar asked him, are you guilty or not? Defendant responded, I not guilty. Count 4. Registrar read and asked him, do you understand count 4? I read to you. Defendant responded, I do. Registrar asked him, are you guilty or not guilty? Defendant responded, not guilty. Count 5. Registrar read and asked him, do you understand count 5 I read to you? Defendant responded, I do. Registrar, are you guilty or not? Defendant responded, not guilty. Count 8, now count 6. Registrar read and defendant, do you understand count 6 I read to you? Defendant said, I do. Registrar, are you guilty or not? The defendant responded, not guilty. Count 15, original 15, now count 7. Registrar read and said, defendant, do you understand count 7 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not? Defendant responded, not guilty. The defendant clearly understands English language, being an educated man. On that day, he had his counsel, including senior advocates such as Kanu Agagi, SN, representing him on that day. The court complied with the procedure of taking the plea of the defendants in accordance with section 2712 and 3 of the Administration of Criminal Justice Act 2015, which provides us 1. The defendant to be tried on a charge or an information shall be A. brought before the court unfettered unless the court says cause otherwise to order, and the charge and information shall be read over and explained to him to the satisfaction of the court by the registrar or other officer of the court. B. Called upon to plead instantly unless where the person is entitled to service of the information he objects to the non-service, and where the court finds that he has not been duly served. 3. The court shall record the fact that he is satisfied that the defendant understands the charge or information read over to him and explained to him in the language he understands, and shall record the plea of defendant to the charge or information as nearly as possible in words used by him. Looking at the above statutory provisions of Administration of Criminal Justice Act, the procedure adopted by this court, the defendant cannot turn round to claim he was misled to take plea after the prosecution has closed his case. It is nothing but the usual habitual flaw of the defendant to cause delay and make the matter to start de novo. This court will not allow matter to be on its court list ad infinitum. On the issue of denial of adequate facilities, the defendant claimed that he was not allowed to consult with his legal representation in confidence at DSS, as the DSS officers were dropping on their conversations. The defendant is facing criminal trial and is entitled to the right to adequate time and facility in preparation for his defense. He enjoys the constitutional right to fair hearing, and in consequence to this right, has the right to adequate facilities as his defense. Section 36 6B of the Constitution of the Federal Republic of Nigeria 1999 amended provide every person, I quote, every person charged with criminal offence shall be entitled to be given adequate time and facility for the preparation of his defence. See the position of the Supreme Court in respect of this provision as initiated in Igwe and the state citation supplies. As part of the package of rights available to a person facing criminal charge, he is entitled to all the facilities and enough to time for purpose of preparing his defence. This ties in with the right to presumption of innocence under Section 36(5) of the Constitution of the Federal Republic of Nigeria 1999 as amended, which stipulates that until a person is declared guilty by a court of law, he is presumed to be innocent. The provision was the subject of interpretation by the Supreme Court, particularly by my noble Lord Akat A.S.C. in Okoye and COP, citation supply, where my Lord held, and I quote, the moment an accused person is facing a charge, his personal liberty is at stake, and before that liberty is taken away, he must be afforded every opportunity to defend himself. Once he becomes aware that he has a charge hanging upon his neck for an infraction of the law and makes a request either orally or in writing for any facilities to prepare his defence, the court must accede to his request and the prosecution has to comply. The facilities that must be afforded to the accused person are the resources, anything which will aid the accused person in preparation of his defence to the crime for which he is charged. This, no doubt, includes the statements of the witnesses interviewed by the police in the course of the investigation, which might have absolved the accused of any blame or which may assist the accused to support such favourable witness that the prosecution counsel may not want to put forward to testify on oath. See case of Nweke and the state citation supply. The defendant did not provide any credible evidence as to this allegation of airdropping. The court, however, in order to do justice to him and suspecting that he was looking for another way to delay this trial, allowed him to consult with his lawyer on the 22nd day of October 2025 in the courtroom. Thus, the court had to vacate the courtroom for him for his lawyer to use. Despite this magnanimity by the court, the defendant did not make use of this opportunity. On the following day, the counsel withdrew his appearance. The defendant decided to defend himself, making the opportunity given to him to use the courtroom to be useless and of no purpose. Despite the fact that he is not a legal practitioner, he began using some of his counsel who he had earlier disengaged to act as legal consultants to him. The court even kindly ordered the DSS to allow these consultants have free access to him. This is in compliance with Section 36 of the Constitution of the Federal Republic of Nigeria, which provides for access to legal practitioners. Most of these legal consultants were always present in court. There is nothing to show that he was denied adequate facilities to prepare for his defence. He had enough time to prepare. Had been represented by senior advocates such as Nnamdi SN, Onyeshi Ipe Azu SN, Emeka Ipob as SN, Paul Inokoro SN, how to not get SN among others before they were suddenly disengaged. And the defendant decided to represent himself, which this court suspected was also to cause another delay in the hearing of this matter. His allegation holds no water in the light of the facts and circumstances in this case. Consequently, this issue is resolved against the defendant. On the issue of extraordinary renditions, there are instances where a person commits offence against a country while residing in another country or flees the country soon after committing the same crime. In such instances, the country against which the offence is committed will request the country in which the suspect is residing to release him to it. The process is known in law as extradition. Extradition therefore refers to a legal process in which a state renders a person accused of committing a crime to the state against which the crime was committed, known as requesting nation. The Supreme Court in AG of Federation versus Enubuwa citation supply subsequently explained the concept of extradition as follows. Extradition is a cooperative legal process of one state called the surrendering state or authority which renders an individual to another state called the requesting state for prosecution or for punishment for crime committed within the requesting country jurisdiction. Extradition process is usually spelled out in bilateral or multilateral extradition treaties or agreements. Extradition becomes necessary when it a trial in which the accused person is not physically present. Extradition is distinguished from other modes of forceful removing undesirable person from a country, such as exile, expulsion, deportation. Extradition procedure are usually determined by the terms of the treaties between individual countries or by multilateral agreements between group of countries, such as the Commonwealth countries or the countries of the European Union. The receiving government then refer to its law. Its treaties specify obligations to the requesting nation and decide whether or not to extradite the person named in the warrant. Treaties signed in recent decades tend to take a dual criminality approach, classifying an extraditable offense that are punishable in both jurisdictions. Other extradition treaties, by contrast, tend to list covered offenses. Usually, the requesting and surrendering nation have a treaty or agreement which allows for such transfer. Nigeria, for instance, is signatory to regional agreements like the ECOWAS Convention on Extradition and other multilateral schemes such as the London Scheme for Extradition, which within the Commonwealth. The London Scheme for Extradition within the Commonwealth enables Nigeria to request and surrender fugitive to member nations of the Commonwealth. On the other hand, extraordinary rendition is an extrajudicial measure to forcefully bring suspect or defendant to the country against which an offense is committed. These extraordinary measures may include adoption. The Supreme Court of Nigeria alluded to this in the case of Federal Republic of Nigeria versus Nnamdi Kanu in SC/CR/13C1/2022, where my noble Lord Agim DSC held, and I quote, generally abduction or kidnap or any form of illegal removal of an accused from the territory of a state to another to face criminal trial or for a reason is prohibited by law. Extraordinary rendition or any other transfer without due process is unlawful. There is no doubt that the illegality in the process of bringing the respondent to Nigeria for the criminal case brought by the appellant against him in Nigeria, the attendant massive violation of his rights, render his prosecution by the appellant unfair and oppressive. Why extraordinary rendition measures unquote, why extraordinary rendition measure may seem illegal on the face of it, the way and manner in which the attendance of a defendant is secured does not dictate his trial. In the United States of America, this is known as Kelfibri doctrines. This doctrine developed through the case law, notable cases of Kel versus Illinois, 119, U.S. 436, 1886, and the case of Freebie versus Collins, 342, U.S. 519, 1952, where a messenger forcefully kidnapped the defendant from Peru and brought him back to the United States, even though he had been sent to Peru with a valid warrant and instructions to obtain the defendant with the cooperation of the local authority. Addressing Kel's due process challenge, the Supreme Court of the United States held that, and I quote, such forceful adoption is not sufficient reason why the party should not answer when brought within the jurisdiction of the court, which has the right to try him for such an offense and presents no valid objection to his trial in such case. In Freebie v. Collins, 342 U.S. 519, 1952, it was a case where the defendant was tried and convicted in the state of Michigan after being adopted by Michigan authorities from Chicago, Illinois. Applying its decision in care, the Supreme Court upheld the conviction of the conviction over challenges based on due process and federal kidnapping law. The essence of Kel's Freebie doctrine is that even though the act of rendition is illegal,
hey guys, big news! Coke is giving out over 250 million naira in cash and prizes.
US 1992. Alvarez Mission, a Mexican citizen, was adopted and brought to the United States at the direction of the Drug Enforcement Administration. The Supreme Court of the United States held that despite his forceful adoption from Mexico by United States officials, it did not affect the validity of his trial in the United States. As said earlier, the issue of extraordinary rendition is quite a criminal issue, which must be proved beyond reasonable doubt in accordance with Section 135 of the Evidence Act 2011. The law in Nigeria is strict that even a civil matter, once a criminal element is introduced, it must be proved beyond reasonable doubt. For instance, where an allegation of forgery is introduced in a civil proceeding, the standard of proof is proved beyond reasonable doubt. See the case of Minister of Executive and Surveillance Consultancies Services Limited and another. Citation supply, where the Court of Appeal held, and I quote, every forgery involves an alteration of documents, but not every alteration of documents amounts to forgery. Forgery involves alteration with a fraudulent intent. In fact, an incident of forgery must be specifically pleaded and proved even in civil matters, as in this case beyond reasonable doubt. The appellant in this appeal has made allegation of forgery, but failed to prove it. In the case of forgery, both the original document and the fake must be produced in court for examination. The appellant failed to produce any documents in proof of these forged documents. Allegation of such forgery in any civil matters is criminal in nature. Therefore, proof is beyond reasonable doubts. See also the case of Muni versus Federal Republic of Nigeria, among other authorities. The evidence in proving an unlawful extraordinary rendition must be oral evidence obtained which allows the adverse party to cross-examine the defendant on his oral evidence. The defendant only sought an affidavit. So the fact that the affidavit evidence is best used in civil proceedings, where the standard of proof is on balance of probability. The affidavit filed by the defendant is grossly insufficient to establish if indeed he was extraordinarily arrested or he was illegally brought to Nigeria. The gap in evidence will therefore mean that no evidence was left regarding the extraordinary rendition. Assuming, without considering, that there was evidence regarding the extraordinary rendition, the court will consider the effect of the extraordinary rendition on the validity of the trial of the defendant. The defendant, in his written address, has argued strenuously that the way he was brought back from Kenya was illegal and thus initiates his trial before this court. He relied heavily on the decision of the Court of Appeal in Federal Republic of Nigeria versus Kanu in appeal number CA/ABJ/CR/625/2022, delivered on the 13th day of October 2022 on the issue. The court held, and I quote, "The consequence of this session, I hold that the respondent is prohibited from being detained, tried, or otherwise dealt with in Nigeria for or in respect of any offence allegedly committed by him before his extraordinary rendition to Nigeria. The lower court thus has no jurisdiction. I further hope to try the appellant on counts 1, 2, 3, 4, 5, 8, and 15, which were retained by it, being charges allegedly committed by the appellant prior to his extraordinary rendition. In addition, by the forceful adoption and extraordinary rendition of the appellant from Kenya to the country on the 27th day of June 2021, in violation of international and state law, the lower court or indeed any court in the country is divested of jurisdiction to entertain charges against the appellant, and I so hold, unquote. When this issue came up before the Supreme Court, the Ipob court, in Federal Republic of Nigeria versus Kanu in SC/CR/1361/2022, delivered on the 15th day of December 2023, the Ipob court held para ML Gaba JSA, and I quote, my noble Lord M.L. Gaba.
For a tasty meal, do not compromise. Choose gold.
Be with the Lion Council for the appellant that the procedure used in bringing or producing the respondent before the trial court for the trial of the offences in the counts of the charge in questions in respect of which he was validly arraigned did not affect or even go to the statutory jurisdiction of that court to proceed with that trial. The procedure, mode, manner by which the respondent was produced before the court is in before the trial court is in law extraneous to the statutory jurisdiction vested or conferred on the trial court to try or adjudicate over the offences in question, particularly after the valid arraignment of the respondent and his plea thereto. The procedure used in producing the respondent to face his trial after the arraignment and plea to the offences and after jumping the bail granted to him by the trial court cannot reasonably be said to deprive or rob that court of the requisite statutory jurisdiction to adjudicate over or try the offences in question. In the above premises, the lower court, which is with the respect due to it, took its eye off the ball when it filed off the statutory jurisdiction vested or conferred on the trial court to subject it to procedural law dealing with the procedure for the arrest, extradition, or rendition of runaway fugitive offender to and from a foreign country. The provision of the Extradition Act, Cap E25, Law Foundation of Nigeria 2004, articles and parts of the UDHR 1964 and pronouncement of foreign courts on them referred to and solely relied on by the lower courts to hold that the procedure used or employed to produce the respondent before the trial courts to continue his trial and drop that court of jurisdiction to adjudicate over or try the offences in question. Did not create, define or punish said offences. Neither did any of them confer or vest the statutory judicial power and authority or jurisdiction to try and adjudicate over the offences in respondents. Was charged with and validly arranged for. Rather, they all merely provide or prescribe for the general procedure to be adopted in respect of their respective subject matter that do not include and have nothing to do with creating, defining, or punishing offences, and vesting or confining judicial power and authority or jurisdiction on courts to advocate over or try such offences. Once again, these laws and rules, conventions, etc., do not take away, deprive, or rob the jurisdiction of the trial court to adjudicate over or try the offences the respondent was arraigned for on the basis of procedure used or employed to bring or produce in before the trial court for continuation of the trial. I must emphasize that even this court, as the apex court in Nigeria, cannot, by pronouncement, take away, deprive, or even fetter the jurisdiction or conferred or vested on the court of record by the constitution of or a statute, let alone pronouncement by foreign courts on such foreign international convention, treaties, and agreements, or even if domesticated. In these results, the issue is resolved in favor of the appellant to the effect that the trial court is absolutely vested or conferred with the requisite jurisdiction to adjudicate over and try the offences in the retained count of the charge the respondent was validly arraigned for, and that the procedure used and employed to bring or produce in for the continuation of the trial did not rob or deprive that court of jurisdiction. It was an error in law for the lower court to resort to and hold that the procedural law or entirety different subject matter of arrest, extradition, or rendition of runaway fugitive offenders accused person from foreign country deprived or robbed the trial court of the statutory jurisdiction. My Lord argued in the same case also held, and I quote, the established case law through the cases is that even though a strict alliance to statutory prescriptions concerning pre-trial criminal processes, the processes for bringing the accused to court for trial is a sine qua non for fair trial. Violation of the fundamental rights of an accused person or other unlawful action by the prosecution at the pre-trial stage give the accused person the right action for remedy for violation of his fundamental rights and other civil remedy, and has no effect on the validity of the whole criminal proceedings against him and the jurisdiction of the court to entertain the proceedings and try him, provided the facts alleged against him disclosed an offence created by written law and a
Food is ready.
So the established case law in Nigeria is that violation of fundamental rights of an accused person and any should not affect the jurisdiction of the court to try ensuring criminal cases and the validity of such case. That is the basis for the admission of relevant evidence obtained from illegal searches and seizure or searches that violates the accused person's fundamental right to privacy. In Nigeria, there is hardly any case where the jurisdiction of a court to try a case is declared to be ousted by or validity of the case declared initiated by the unlawful arrest and detention of an accused person at the pre-trial stage of that case, or by any unlawful extrajudicial action of the prosecution after arraignments during the pendency of the proceedings in court. The Court of Appeal has introduced a departure from the established case law on the points in Nigeria. What is not clear is if the departure is limited to cross-border cases or include cases within Nigeria. But the erudite statement of the House of Laws in House versus Osprey relied on by courts of appeal are couched in terms that suggest that they apply to all cases. This profound judicial restatement appears to give paramount consideration to preventing executive lawlessness, protection of the fundamental rights of the accused, preservation of the rules of law, promotion of rights for the territorial sovereignty of states, enforcement of international law, adherence to due process of criminal law to ensure that prosecution does not benefit from abuse of his power and abuse of court process. But the reality in Nigeria particular situation is that no allegation of commission of a crime will be tried if the court declines jurisdiction to try a criminal case or invalidate it because of the violation of fundamental rights of the accused person or other unlawful actions of the prosecution that occur in the process of investigating a criminal complaint against him or in the process of initiating the criminal case arising from such complaints or in process of bringing him to court or in dealing with him while he is standing trial. This is because criminal law enforcement officers routinely engage in unlawful actions and raising violation of fundamental rights of suspects in the investigation and prosecution of virtually all criminal matters. The effect of the holding of the Supreme Court is that notwithstanding the legality or otherwise of how the defendant was brought back from Kenya, it does not invalidate his trial. The court will foretold the line set by the Supreme Court as the apex court of the land. His decisions are final, overrides all other courts, including the Court of Appeal, which defendants has erroneously relied on heavily. Kindly see Section 235 of the Constitution of the Federal Republic of Nigeria 1999 and the case of Adama Tanker Okri Services Limited against CBN citation supply. The fact in this case is more distinguishable. The fact in this case is more distinguishable even than in February case in US with respect to the effect on the jurisdiction of court to try the defendant as held by the Supreme Court per Gamba AS. In that case, the defendant was already arraigned before this court, and in this case, the defendant was already arraigned before this court, and the jurisdiction of this court had been activated as far back as 2015. More so, he had been compensated monetarily in suits he filed in Kenya, unlike in February case, where the defendants were not on trial before their rendition. Despite the fact that in February they were not arraigned before the extraordinary rendition, their trial were not invalidated in the US. The defendant in this case, on being granted bail, was alleged to have joined bail by leaving Nigeria, and for 4 years. The trial was granted until he was rearrested in 2021 in Kenya. This action of the defendant makes him a fugitive. In this case, the trial has begun and the charge has been filed and read to the defendant before the alleged extraordinary rendition. He cannot then claim that the trial is vitiated by the extraordinary rendition. The alleged rendition of 2021 will not deactivate the jurisdiction of the court activated since 2015. I hold without hesitation that this is an exception to the effect of extraordinary rendition in international law. Even if the extraordinary rendition was wrongful, the remedy for it is at best monetary damages in civil proceedings. The court is aware that a court in Kenya had ruled on this issue and awarded consequently charge is that in a written law. And in this subsection, a written law refers to an act of National Assembly or a law of states, any subsidiary legislations, instrument under the provision of the law, unquote. The above means that a person to be tried and convicted, the offence must be in existence and provided for under law, a law in force at the time. See the position report of appeal in Daniel versus Federal Republic of Nigeria, citation supplied. The law is also settled that the trial and conviction of any person upon a repeat law is a nullity. This was the position of the Court of Appeal in IGP versus Ugundimu, citation also supplied. A law, once repealed, ceases to have any life and must be treated as dead. And the Supreme Court in State versus Egidia has initiated on this, and I quote, the law is settled that a repeat law no more has legal life. Thus, it cannot be cited as if it still exists. If it must be cited at all, it must be cited as a repeat law, which has no life to influence an argument. A repeat law cannot be the basis for any comparison with existing law. It cannot be quoted side by side an existing law as learned advocates did. Now, the defendant argued that the Terrorism Prevention Act 2013 had been repealed by the Terrorism Prevention Act of 2022. Thus, the trial has become spent. The argument by the defendant is quite interesting. It is interesting because it shows the stark misunderstanding of the law by the defendant, as well as his willful disregard of the facts accumulating in his trial. Firstly, the defendant is charged under the Terrorism Prevention Amendment Act 2013. The extant charge is as to offences allegedly committed by the defendant between 2018 and 2021. As at when the extant charge was filed, the Operational Terrorism Act in Nigeria was the Terrorism Prevention Amendment Act 2013. That act was duly passed by the National Assembly and signed into law by the President, Goodluck Jonathan. It empowered the court to try terrorism-related offences and also apply what constitutes act of terrorism under Section 30 of the 2013 amendments. The act provides thus, and I quote, the Federal High Court located in any part of Nigeria, regardless of where the offence is committed, shall have jurisdiction to try offences under this act. Unquote. Section 1(2) of the same law defines terrorism as follows, and I quote, any act deliberately done with malice and for thought which may seriously harm or damage a country or an international organization is intended to intimidate a population, compel a government to act or abstain from acting, destabilize a fundamental political, constitutional, economic, or social structure of a country, unquote. The above provision were enforced 2 years before the defendant's arrest in 2015, meaning this court had requisite jurisdiction to try him then. His initial trial, therefore, was based on an existing and valid legal foundation as at then. This instance means that at the time he was charged, the Terrorism Prevention Amendment Act 2013 was the extant law of the land. It would have been different if the defendant's offences were allegedly committed after the Terrorism Prevention Act 2022. have been enacted. The can be no reasonable dispute that the criminal code is an existing statute or act that was or is in force in Nigeria, which the court has the duty to take judicial notice in this appeal, pursuant to provision of section 122 of the Evidence Act 2011. In addition, the court is also entitled to take judicial notice of the codification and publication of all the acts or statutes, the subsidiary legislations, enactments or passed by the National Assembly as contained in the laws of the Federation of Nigeria, published by or under the authority of the Federal Ministry of Justice of Nigeria as various times, because we here are concerned with laws of Federation of Nigeria 2004, in which the Criminal Code Act is indicated to be. I have noted and pursued the laws, perused the law and acts codified and published in the laws of Federation 2004 as published. The Criminal Code Act is published in Volume 4, comprising of Chapter C2, C24 to Chapter C48. It is in Chapter C38, which is subsequently indicated as Cap 38. The Criminal Code Act is in Chapter 38 of the Laws of Federation of Nigeria 2004, and it's also called or shown to be Cap C38 in Volume 4 of the publication. It is apparent, therefore, that the Criminal Code Act is not Cap 45 or Cap C45 in Volume 4 of the Laws of Federation of Nigeria as indicated in Count 15 of the charge against the respondent. Rather, Criminal Code Act is Chapter 38 or Chapter C38 in the Laws of Federation of Nigeria 2004. However, the same Laws of Federation of Nigeria 2004, Chapter 45 or Cap C45 is the Custom and Excise Management Act. A calm reading of the details of the facts stated as constituting the offence mentioned or named therein will clearly and undoubtedly reveal that it deals with offence punishable under the provision of Section 47(2)(ba) of the Custom and Excise Management Act C45, Laws of Federation of Nigeria 2004, which provide as follows: 47(2) if any person A imports or causes to import any goods or concealed in a container holding goods of different description he shall be sentenced to imprisonment for 5 years without the option of harm. It follows, in the above circumstances, that the mention of the Criminal Code Act as being Chapter C45 and C45 in Laws of Federation 2004 is a mere mistake in place of correct law. The Custom and Excise Management Act, under which the facts alleged to constitute an offence in Cap 15 is punished or punishable. The offence in Cap 15 is consequently recognizable and grounded in an extant existing law in Nigeria, in which it was defined and described. It is now on good law that a child prepared or filed for offence under a wrong law will not be rendered invalid or incompetent merely on that.
Authentic Big Bowl rice, 50 kg and 25
defined and punishment provided for in an extant law. In the results, the answer to the answer posed earlier in this affirmative involves 2 counts, and that the Terrorism Prevention Amendment Act 2013, under which the offences of count 1, 2, 3, 4, 5, and 8 as well as Cap C45 and Cap C45, Custom and Excise Management Act, all contained in Laws of Federation of Nigeria 2004, are extant and existing law, which provide for, under which the offences in the counts of the charge retained by the trial courts are punishable and punished. The offences once more are recognized, cognizable, and ground instance and existing law in force in Nigeria. Assuming without considering that at the commencement of the Terrorism Prevention Amendment Act, the Terrorism Prevention Amendment 13 was repealed, and such is liable to affect the validity of the defendant's trial. I refer to section 98 of the Terrorism Prevention Amendment Act 2022, which provides 98. 1. The Terrorism Prevention Act number 10, 2011 is repealed. 2. Any regulation, order, requirements, certificates, notice, direction, restrictions, authorizations, consents, applications, ongoing cases in courts, requests or things made, issued, given or done under the Repeat Act shall, if enforced at the commencement of this act, continue to be enforced and have effect as made, issued, given, or done under the corresponding provision of this act. 98.3 provides any proceedings, prosecutions, sentence, judgments, charge, or cause of action pending or existing immediately before the commencement of this act under any of the repealed acts in respect of any rights, interest, obligation, or liability may be continued and commenced as the case may be, and any determination of any court of law, tribunal, or other authorities or person may be enforced to the same extent that such proceedings, prosecutions, sentence, judgments, charge, course of actions, or determination might have been continued, commenced, or enforced as if the act has not been made, unquote. The import of this provision, particularly section 98.3, is served as a saving provisions which ensure that the amendment of the act does not affect the validity of trial began under the Repeat Act. This saving clause or preservation provision is aimed at ensuring that pending proceedings or order or court are not washed away as a result of the commencement of the amended Act 2022, but to ensure a smooth transition from the repeal Act to the amended Act. The sum total of this is that the enactment of the Terrorism Prevention Amendment Act 2022 does not vitiate the trial of the defendant fairly commenced under the Terrorism Prevention Amendment Act 2013. Consequently, this issue is resolved against it. With respect to the substantive issue, I must start the resolution by outlining the effects of the action of the defendant in failing to put in his defense despite several opportunities afforded him by this court. Generally, the three options available to him upon the no-case commission to argue that the prosecution has not made out a prima facie case against him to warrant him to enter his defense, or that the evidence led by the prosecution so far has been so discredited upon under cross-examination that it will be unsafe for the courts to convict him. Another option open to a defendant is to put his defense where he will be opportune to state as present exculpatory evidence in his favor. The third and the final option is to rest his case on that of the prosecution. The defendant in this case choose to make no case submission, and this court overruled his no case submission on the 26th day of September 2025 and ordered him to put in his defense. It is his temple of justice, passionate about justice, as an apostle of Jesus Christ. I begged the defendant passionately and severally, but the defendant was obstinate and refused, and the court had no choice than to foreclose him. The effect of this is that the defendant has chosen to rest his case on that of the prosecution. The defendant this morning confirmed this fact by saying that he has put in his defense. The effect of the defendant resting his case on the prosecution is that it is a gamble, a risky option, which may boomerang if the evidence adduced by the prosecution is believed by this court. The Supreme Court in Adamu and States, citations supplied, held, and I quote, "The law is generally settled that an accused person who, at the close of prosecution case, decided to rest his case on that of the prosecution as presented against him is only exposing himself to risk and gamble. The reason being that if the case is such that even if all the prosecution witnesses are believed, yet the offense as charged is still not proved, then the accused may get away with his case on that of the prosecution. By that choice, the accused will have decided not to explain any part in rebuttal of the allegation made against him. See also the position of Supreme Court in the case of Ajibade and State citation supply, where the support ends, and I quote, appellant elected not to give evidence in his defense, but to rest his case on that of the prosecution. The election is within his rights under the law, but the legal effect of the said election is to leave the court of trial free to accept the uncontroverted evidence of the prosecution in proof of the charge, which the court rightly did, in my view, unquote. See also the case of Hakim Ibisen versus Olajide, citation supplies. The defendant in this case deliberately refused and failed to call any witness and present evidence to his witnesses in reporter of the case of the prosecution. The implication is that he admits the case of the prosecution, and the court is entitled to rely on the uncontroverted evidence led by the prosecution. With respect to count one of the charge, the defendant is facing a charge of committing an act in furtherance of an act of terrorism against the Federal Republic of Nigeria by making a broadcast receipt and act in Nigeria with intent to intimidate the population and threaten that people will die and the whole world will stand still, thereby committing an offence punishable under Section 1(2)(b) of the Terrorism Prevention Amendment Act 2013. The said section provides a person or body corporates who knowingly in or outside Nigeria, directly or indirectly, willfully commit an act preparatory to or in furtherance of an act of terrorism, commits an offence under this act and is liable on the conviction to maximum of death sentence. The ingredients of the offence are drawn from the above are: 1. The defendant must be a person of